as the party grows, there are bound to be groups, bound to be factions, and ultimately who claims superiority? There is no floor to test the house. So only way election can do is to get documents, get affidavits, listen to the parties, and then decide. Here, as Malad just put it, the batting order. Suppose there is a case of split in the house in this particular case. But I am asking a case independent of any kind of, as a general principle of law, what is the role of election commission? Suppose there is a defection crisis in any assembly or parliament and the matter is sub judice either before the High Court or the Supreme Court. Does it stymie? Does it stop? Does it interdict the functioning of the election commission? Is a question which a lordship has to answer. And my humble submission is, when do we avoid parallel proceedings? We generally avoid parallel proceedings
when the jurisdiction is concurrent.
When the jurisdiction is concurrent, and typically there is a higher forum and a lower forum. And as a general group, the subordinate forum will yield to the higher forum. So if a matter is pending in the High Court, say for example in a tax matter, and lordship gives a notice, then typically the officer will not proceed because he will await the decision of the High Court. So parallel proceedings come where the jurisdiction is concurrent, and there is a possibility of the possibility of two authorities coming to contradictory conclusions.
The issue of disqualification would really relate to the membership of that house.
Of that house, that's what
whether a particular state legislature or if the case may be one parliament.
191(2) says you will be disqualified member of that house. It doesn't say anything about the political affiliation, political party membership.
Para 15 is really agnostic on the legislature because that is irrespective of whether there is or there is not any disqualification.
In fact, as I mentioned that political party may not have any member of a particular house also, or it may have members. So what we are concerned is, now if you lordship sees the what I call the structure of a 10 schedule, first one is definition, 2 is the substantive, what is disqualification, 3 and 4 are exemptions to that disqualification, that is 1/3 member and merger. So 2 is the bar, the disqualification, 3 and 4 are exceptions, 5 is also an exception where it says that if you are a speaker, it's very unique for a speaker if he gives up his membership, then when he comes back, he comes under disqualification. 6 is the procedure, which came up for consideration in Kyoto Hon'ble, and 7 are the rules. So if a lordship kindly says every para in the 10 schedule refers to the disqualification of a particular member. So the role of disqualification is basically a person who gets elected on a particular ticket, then leaves the party and comes to it, then you get disqualified.
The only point really, Mr. Datar, is that the issue of giving up the membership of a political party within the meaning of 2(1)(a) is not confined to your activities within the house.
Yes. In my submission, Lord, I would submit that will partly depend on, because what I am submitting is, if
because voluntarily giving up the membership of a political party is not confined to what you do within the folds of the house. Unlike 2(1)(b), which is votes or abstains from voting in the house.
Yes.
But 2(1)(a) is much broader. True. Voluntarily gives up membership of a political party.
No, I'm sorry. I absolutely no.
Therefore, the speaker's power to determine that is not therefore confined to what takes place within the fold of the house.
Lordship will see there are case laws which say, what is the meaning of voluntarily giving up membership? There are judgments which say, if a particular member of party X has attended all the meetings of party Y, he has participated in the functions of party Y, then has he given up his party or not? So in some cases they said, yes, it's amongst giving up membership. But that's really outside the scope of this reference. That's why I didn't. So when you say voluntary, Lordship is right. That's why under clause 6, the speaker is called upon to say that Mr. X, he attended the rallies of this party. Not the reported judgments are there, I can circulate them. He attended the rallies of this party. He attended the meetings of this party. He was seen in this particular party. The Supreme Court has said no, but his name is still continuing in the register of members, therefore he has not given up. In 2 cases, they said this itself indicates that he has given up his membership. So is it it can be impliedly giving up also, physically actually giving up also. But what I'm submitting is,
but one thing is very clear that 2(1)(a) as well as 2(1)(b) is member specific.
Member specific.
15 is not in that sense member specific. It deals with a faction as to whether a particular faction represents a political party.
Now, Lordship will come.
It refers to a collective group as to whether that represents.
Yes. Now, Lordship will come. Yes. So, what I'm submitting is, Para 15 basically refers to the collective right, the collective party. Who is the real party? And if your lordship now comes to Para 15, which your lordship saw a number of times, I will go through it again. And if lordship, your lordship has seen Sadiq Ali several times, I won't repeat it. But the first two paragraphs are very interesting. How did this problem straight away come about? Because Nijalingappa came to the Congress so, and Jagjeevan Ram was Congress chief, and we all gone through the controversy in those days, the Congress so, the Congress, etc. And then the argument was that the Congress had majority in the Congress working committee. Lordship, can you just your broad outline of that case?
Sadiq Ali is of which year actually?
1975.
75.
But the split took place in
1969.
Yes.
We were, so in that sense, Sadiq Ali was doing a bit of a postmortem on what happened.
No, but what happened was because Justice Khanna remarks in an abnormally prolix order. The prolix itself is abnormal, but his lordship says abnormally prolix order of 437 pages. The Election Commission has drawn. There, what happened was, lordship will just keep on just 2 point lordship will know. Sadiq Ali deals with 72 Supreme. Sorry, it's Sadiq Ali says 72 4 SCC 664. Sadiq Ali says the Election Commission went by 2 tests, and that Supreme Court approved. One was the test of majority. Test of majority with Parliament and individual houses. They took the strength of the Congress in the Lok Sabha, in the Rajya Sabha, in the individual houses, and they said that out of these number of MPs, X are in the Jagjeevan Ram faction. Y are in the Nijalingappa faction. They go statewide. But you want to see that, I can show that later. That's the breakup. Then they say, at the All India Congress Committee, working committee, where more than some 2,000 odd members were there, a large majority voted for this particular group. And therefore, the election came to the conclusion that the actual Congress was the Congress J and not the Congress O. And the court said nothing wrong with it because they have gone by test of majority in this. The point is not what we are on. The point is, Election Commission is free to decide as to how it tests the majority. And by and large, what they are doing is, and I've got cases in my compilation. We had recently problems in Tamil Nadu where who was the correct member of the All India NDMK. Hearings took place, they came right up to the Supreme Court. And what the Election Commission does, they take a complaint, ask both parties to give their submissions, then evidence, affidavits, etc. are admitted, and then inquiries. Now, please see my notice under para 15. I am humbly submitting that this notice has nothing to do with the election. But when the matter came up, I told the court that this is just the first step. There is no need to stop me. Let all the inquiry go on, involve the matter. But then the court said, please, what is documents you asked for? Now, if your lordship sees the notice, it has got nothing to do with the membership of any person of the party or of any house. There is an MP or an MLA. Nothing. Secondly, my lord, by submitting this application by respective sites, none of the provisions of 10 schedule are attracted. Because 10 schedule disqualification is limited to 218, 21B. So my submission is, as somebody mentioned, para 15 is like, say, inner party democracy. Suppose as the party grows, there are bound to be groups, bound to be factions, and ultimately who claims superiority? There is no floor to test the house. So only way election can do is to get documents, get affidavits, listen to the parties, and then decide. Now, Lordship will just see how we have done it in one case from Tamil Nadu. I think that Anna DM.
I don't think we need to go into the issue.
No, what I'm saying is, because Lordship will see, number of advocates have appeared, numerous documents have been filed, hearing has been conducted. Yeah.
Yes. So, Datar, you have already said so in your paragraph 3,
Yes.
the procedure to be followed by the election commission.
Correct.
You have already stated so.
Thank you, Mr. Datar.
So my